Hyundai knew the ICCU would fail and kept selling. Before the first lawsuit, before the first news report, an internal technical bulletin had already named the exact component now being litigated in federal court. It described the symptom. It described the failure sequence. And then Hyundai's customers were told nothing. Owners of the Ioniq 5 and Ioniq 6, vehicles priced between $40,000 and $60,000, were losing full drive power mid-highway. No warning light. No slow fade. 70 miles per hour, then nothing. One NHTSA complaint, filed fall of 2023, reads, "Vehicle completely lost power while traveling at 65 mph on the interstate. No prior warning. Car coasted to a stop in the right lane." That is not a malfunction, that is a safety event. Hyundai's public position through late 2022 and into 2023 was measured. Isolated incidents under investigation, no systemic issue confirmed. But in October 2022, Hyundai had already issued a recall in South Korea. Same component, same failure mode, same fix. That recall covered tens of thousands of Ioniq 5 vehicles in Hyundai's home market. The U.S. recall, for the same ICCU, the same power loss sequence, came considerably later. By then, the lawsuit had already been filed. The Korean recall is a public record. The gap between it and the American one is now exhibit material for plaintiffs' attorneys. The internal service bulletin drafted before the litigation describes the ICCU failure sequence in clinical detail, how the auxiliary battery could drain without triggering a dashboard alert, how the unit could enter a fault state under specific thermal or load conditions, and how the result was sudden, unannounced power loss. Dealers received it. Technicians were told what to check. Customers received none of it. It gets worse. Dealer-level ICCU replacement rates were already running at volumes inconsistent with random component failure before any public recall was issued. The field already knew. Hyundai hadn't said a word. The component at the center of the complaints, the Integrated Charging Control Unit, the ICCU. This is not a peripheral part. The ICCU manages power flow between the high-voltage battery system and the 12-volt auxiliary battery. When it fails, it doesn't just disable charging, it can cut power to the systems that keep the vehicle moving. Engineers inside Hyundai understood this architecture before the Ioniq 5 shipped. The dependency was designed in. The single-point risk was known. The question is, when the failure pattern became known. Hyundai's public position, through late 2022 and into 2023, was measured. Isolated incidents. Investigating. No systemic issue confirmed. But the NHTSA complaint database told a different shape. The reports weren't random. They weren't scattered across different model years or configurations. They concentrated. Specific vehicles, specific conditions, specific symptom signature. Pattern recognition at that scale doesn't require a laboratory, it requires someone to look. The internal service bulletin, drafted before the litigation began, suggests someone did look. The bulletin existed. The failure was described. The public wasn't told. That's not an oversight. That's a sequencing decision. In January 2024, a class action lawsuit was filed in federal court in California. The plaintiffs were not industry insiders or professional litigants. They were Ioniq 5 owners, teachers, engineers, a nurse who described losing power while merging onto a freeway with her 2 children in the back seat. Her complaint states she had no prior warning, no error message, no time to react. The car simply stopped delivering power. She had owned the vehicle for 14 months. The lawsuit named Hyundai Motor America and Hyundai Motor Company as defendants. The core allegation, Hyundai knew about the ICCU defect before vehicles were sold, failed to disclose it to consumers, and continued selling affected models without retrofit or redesign. The filing cited internal documentation, including service records from Hyundai dealerships where ICCU replacements were already being performed at rates inconsistent with random component failure. High replacement rates at the dealer level before a public recall mean one thing. The problem was already in the field, and the field already knew. Dealers were replacing the part. Hyundai hadn't issued a recall. Those two facts don't coexist by accident. Hyundai's U.S. recall, when it came, covered approximately 64,000 vehicles. Ioniq 5 and Ioniq 6 models from the 2022 and 2023 model years. The remedy: inspection and ICCU replacement if necessary. The framing in the recall notice was careful. It described the issue as a potential defect that may cause a warning light or possible loss of drive power. Possible. Owners who had already coasted to a stop on a live highway in the dark read that language and recognized it as something less than candid. The lawsuit goes beyond the recall. The plaintiffs argue that replacement of a defective ICCU with an identical ICCU is not a fix. It's a deferral. If the root cause is architectural, if the design creates conditions where the unit fails under predictable stress, then swapping the part resets a timer rather than solving a problem. As of the filing, Hyundai had not disclosed engineering changes to the ICCU design itself. They replaced the unit. They did not explain why it failed in the first place. There is a detail in the NHTSA complaint record that doesn't fit the narrative of isolated incidents. Several owners reported the failure occurring within weeks of taking delivery, not after years of use, not after high mileage, within weeks. One complaint logged the failure at 1,200 miles. If the unit fails at 1,200 miles, the defect was present at the factory. It shipped with the car. The customer drove off the lot with it. Who benefited from the delay between the Korean recall and the U.S. action? During that window, Hyundai continued selling Ioniq 5 and Ioniq 6 units in the American market, its fastest-growing and highest-margin EV segment. The Ioniq 5 was Hyundai's entry point into a buyer class it had never captured before, $40,000 customers who were choosing between Hyundai and Tesla. Every month the recall was delayed was another month of full-price sales to buyers who did not know the ICCU was already a documented liability in another jurisdiction. That is not speculation. The Korean recall is a public record. The U.S. sales figures are a public record. The timeline is arithmetic. The class action is proceeding. Hyundai has not settled. As of early 2025, additional plaintiffs have joined. The complaint has expanded to include allegations of fraudulent concealment, a higher legal bar than simple negligence, one that implies deliberate awareness and deliberate withholding. Fraudulent concealment, if proven, changes the damages calculation entirely. It opens the door to punitive damages. It transforms a product defect case into a corporate conduct case. Hyundai's legal team knows this. So does every other manufacturer watching this litigation. Hyundai has invested heavily in its safety narrative. 5-star ratings, driver assistance systems, a public commitment to zero fatalities by 2040. That language exists on their corporate responsibility pages right now. What also exists? A federal lawsuit, a cross-continental recall timeline that plaintiffs call a cover, and an internal document that named the failure before the public knew there was one. The commitment to safety and the timeline of action are not the same thing. The bulletin existed before the complaints. The Korean recall existed before the American one. The replacements were happening before the disclosure. Every piece of this was sequential, documented, dated. This wasn't a company caught off guard by its own product. It was a company managing the distance between what it knew and what it said. That distance has a name in a court of law. When a company builds a reputation on trust and then treats information as a liability to manage rather than a safety obligation to fulfill, the product was never the real risk. The decision-making was. This is Redacted Chapter. We dig up the corporate stories they buried. Subscribe. The next one's already in the cut.